It is okay. Why did you sign?
The only ones that we have given authority, yes, and it has already the list of those whom we have given authority and already implemented this court.
So
This court, but all the lawyers who are appointed, their names were read here, and they have our instructions to represent us.
Ladies and gentlemen, I expect maximum. I respect this court, and I don't want to provoke anybody. Your colleague, Aaron, will be handled after this case. So we can proceed.
Uganda versus Dr. Besigye Vs Gov't.
Lieutenant Second Lieutenant Regina Nazara, Second Lieutenant Anton Phillips Orupot. Those are the attorneys for the state. This court, that was on the or have not given instructions to any lawyer to represent him. And those were his words. And lawyers who were claiming to represent him were advised to follow the instructions, the rules of procedure. And among those whom Colonel retired Dr. Besigye Vs has given instructions, written instructions. So far we only have Adi Wara, Frederick Mbanga, and Aparo Katumba, all from AF and Mbanga company advocates. So I don't know whether there are others who have also complied, but that was the start. We are yet to know.
And honorable members. Maybe, sir, before that, I think it is the registrar to update code. Those who have complied
I think what you are saying is right. First registry, that was from the state. Registrar.
I'm an office of this honorable court, and I've always addressed you before. I have a right to address you, Mr. Chairman. I have a right to address you before the registrar comes, because let's not conduct this as an LC court.
And if possible, look at those papers.
Mr. Chairman, I do request that we comply with.
My lord,
Mr. Chairman, I do request we comply with the dictates of the Constitution.
Please, Council, first.
Yes, we have a right.
Time to talk.
Yeah, but we seem to be acting on the orders of the judge advocate. You had given me permission to address you, then he intervenes and gives contrary orders.
Council Kwabo, this court has rules of procedure.
Yes, yeah, but we are also advocates, and there is a constitution here. We have a constitution. But before we address you on this, on the issue of instruction,
Much obliged, my lord.
Do we have a right of audience, Mr. Chairman?
My lord.
Just a minute, Mr. Chairman.
Telling you to hold on and we finish with the registrar and then you'll talk.
But on the 9th December 2024, the accused person, retired Colonel Dr. Kiza Besigye and Haji Obed Lutale, formally notified the convening authority as required by Regulation 62, Sub-Regulation 3, notifying the authority that they had appointed a team of lawyers that included Ernest W. Kalibala, Frederick J. Mpanga, and Apollo Katumba, all from AF Mpanga Advocates. And they appended written instructions from the accused persons, their other lawyers who volunteered to file, that they had intentions of also representing the two accused persons. But I did not have any instructions from the accused persons. That's all.
And the accused persons themselves endorsed. Why don't you follow that, Mr.
Do we even have a right to explain ourselves, Mr. Chairman, before you? At least can you grant us a permission to explain ourselves before you, at least to hear us?
Then what about those ones who were given authority to represent? What would they say? It is okay. Why did you sign?
The only ones that we have given authority, yes, and it has already the list of those whom we have given authority and already included in this court.
So
This court, but all the lawyers who are appointed, their names were read here, and they have our instructions to represent us.
here, and it is a simple procedure to me. Why don't you follow that procedure and then we proceed?
Including the lead of the team.
We are not saying that we don't want these people to represent you. It is just a matter of procedure. That's what we want.
You are saying that court is following what I'm saying, but I'm referring you to Regulation 63 of our rules of procedure. I am mandated to advise court. I have advised. Now you proceed, but we don't want the name tribunal in this court.
Mr. Chairman, the last time we adjourned was so that you could give time for me to get a practicing certificate. I now want to let you know that you and members know that I do have a practicing certificate, which was issued to me this morning. To also indicate that the last 2 times we have been in court, because this is the 3rd time, you have had submissions from Elias Rukwago. He has been introducing all of us, including Ernest Karibara. It therefore means that it's within the knowledge of Mr. Chairman and the members that the team in court is representing Ms. Dr. Kiza Besigye and Obed Lutale. And we really are taken aback because even the permissions you have granted before on how we should enter the court and that we should come with our tools of trade, all have been flouted by the orderlies today. We have been subjected to very difficult conditions back and forth, such that before you, we are so exhausted as not to be capable of properly representing them. We have also witnessed before this, before your very eyes, the assault of one of the team members. When we come before you, we feel protected by you. But today, that has been violated by the orderlies. If anyone commits a perceived offense, we expect them to be restrained, not assaulted. To be removed, not assaulted. I was at the back. I did not exactly see what happened. So we have serious issues we'd like to address you on, and we seek to be allowed to start normally, not to be taken back to start registering, and we've already been before the court before. It doesn't happen that way. And it is unfortunate that the court is being informed to go back and forth. It becomes difficult. It's a very bad picture, even before the accused persons, because will they expect justice? If every day we come, there's shifting of goalposts. We respectfully urge you to grant us audience, which we already had, so that we are able to proceed. The word of mouth before the court from these two gentlemen is better than any written paper. If they say, oh, these are their lawyers, that is it. For purposes of your record, we can later furnish you with a complete record. For purposes of your record. But for purposes of, we will give you at the end of it. But because they now have told you we are their lawyers, allow us to proceed. Otherwise, it may appear, it may be unintended, but it may appear that we are being denied audience and that the defense of these two gentlemen is being scuttled deliberately.
Your submissions. I wish your colleagues would be behaving like you, so that we could. Now you can hear. These are lawyers also making noise. Ah, what is ah? Look at you. Eh? I don't know. Are you helping the accused people or you are not helping them? You talked of that you revenge us with the required papers. And we talked about this the other time when we were here. Why didn't they fulfill that? Secondly, you are talking about the assault, you are not talking about the conduct of your colleague. What type of conduct is that in the court? I think we also need to behave, because we are not here to show that we are in uniform, we are not here to support, we are here for justice. Nothing else. But the way we are conducting ourselves, I think it may not help us. Instead, it will be affecting the accused persons.
May I respectfully so detail the orderlies? Because every day we are being met by different people with different standards. The first day, 4 hours of standing outside there. I have not even
I think, sir, we are going astray.
And today, allow me to make my submission, for which I may not require your advice, the court will require later. I am saying that we are being subjected to different standards every day. The first day, 4 hours of standing, we have not even recovered from that fatigue. Today, over 2 hours. The second day, the 10th of December, we had an easier time. Today, I am informed, because I was at the back, I couldn't see. All Aaron Chiza wanted was to come in and sit, and he normally sits here. Even if there is no seat, an advocate should not be stopped from approaching the court. It is the court that would direct anybody without a seat go out. So there is something wrong with the way the preparation of the orderlies, and we would urge that there be strict instructions so that there is no back and forth. Before, the 2 times we have come before this tribunal, we have had no complaint about the way that the court, you said court, I will use the term.
Honorable Chairman.
Sorry, yeah, it is not an offense. The way
Honorable Chairman, it is a concept of court.
Saying is this, that Aaron Chisa should not have been stopped from coming in. I myself was stopped from coming in, and other lawyers on the 10th. We went to the back. We were then invited. But unlike me, Aaron Chisa is an advocate of the High Court of Uganda. He is known by the orderlies. So it looks like there was an intention to actually assault him. And we come here respectfully, we address the court, and we leave. And that's all that we need. How is it going to affect the 2 gentlemen on the dock when one of their lawyers is not there. May we respectfully ask for time to withdraw and confer with them so that we may now know what to do without one of us. Because each one of these lawyers has a specific task. The matter before you is the matter of life and death. That is why it has so many lawyers. We ask you respectfully to give us time with our clients.
At least to be listened to. Mr. Chairman.
Honorable Kwago, just take your seat and put the mic down.
But at least a word before you make a ruling.
You see, this, senior counsel is talking of harassment outside, but what I have heard, partly it is caused by your people. That one I'm going to handle. The people, that one will be handled. But once we organize ourselves, because we want to know, yes, you are talking of lawyers, we are seeing them. But now, how can I know that this one is from this firm, this one has what? How can I know? And this is the...
And indeed, you captured the titulars of these advocates, their names, their law firms, and every aspect that was
What did we agree on last time?
Yeah, that's exactly what I wanted to explain, Mr. Chairman.
Do you have papers?
Can I explain, Mr. Chairman? One thing what happened, because the stringent rules he's reading, the judge advocate, would require that the accused person append their signature on the instruction. And we have attempted to access them in Ruzira to process that in vain. Today, if I may tell you, Mr. Chairman, you can ask and cross-check with the prisons authorities if it is possible for anyone to access Dr. Besigye Vs and Obed Lutale. If you visited the Ruzira Maximum Prison, the only way you can talk to them is through a landline, a phone. They are at a distance, so how are they going to sign on those instructions? If you insist on that, it will be a perversion of justice. You'll be perverting justice, Mr. Chairman, because it's not going to practically happen unless you are saying that we do it right now, that we prepare a paper, the list is here, we can present it to them, they sign, we file it. If that can do, if it can suffice, we are ready to comply with that. But if we are to access them in Ruzira, to sign instructions, that is not going to happen. The last thing, Mr. Chairman, he's insisting on PCs being filed with you. We are in a grace period of 3 months. 3 months. Right now, I have a right to practice without a renewed PC. Right now, until 1st March. So we are in January. We have all this grace period to process the practice certificate. I thought, as the advisor of this court, shouldn't even have raised this matter. It's totally very embarrassing that he's raising such a matter when he's supposed to be a senior advisor to this tribunal, general court martial.
Grace period is there. You must come with the preceding certificate. It's what we want.
It expired.
We want that one.
You want an expired one?
Showing that you are practicing.
PC?
Yes, the one which shows that you are practicing, but you are waiting to renew.
The only lawyer who has a 2025 PC now is Martha Karua. In Uganda.
We want the one.
The whole of Uganda.
Listen,
it's only Martha Karua right now.
Bring the one of.
So you say should
bring the one of 2024.
That one is expired.
We want it. We want it. We want a practicing certificate of the preceding year. It shows that you are waiting to renew. Why don't you want to bring it? Others have filed it. Why did they file and you have not filed?
Please, if you are not among the three, I would like to hear from Mr. Karibara.
Mr. Chairman, from the mouth of Colonel Dr. Besigye Vs.
He has somebody sitting in for him. Is that allowed?
Around.
Mr. Chairman, I'm Frederick Mbang.
You are Frederick, okay, Council. It's okay.
And my colleague, Mr. Apollo Katumba, is here. Mr. Kalibala is not present. He's in this post. He's in this post, that's why he's not here. Mr. Chairman, I join issue with my senior colleague that because the year ends on the 31st, the process of inspecting chambers starts near to the end of the year and also continues up to in January and also February. And the Law Council can only issue practicing certificates after they have inspected chambers. So it is correct that we have a grace period up to the 1st of March. So apart from my colleague who has been given special dispensation, today my colleague Mr. Alkwago is correct that all of us, myself inclusive, don't have PCs for 2025, so we are just acting under the umbrella of the grace period. We urge and kindly ask the court to accommodate us, just like the other courts have done, because it is the practice. Otherwise, there would be no advocate going to court, Mr. Chairman. An opportunity to talk to the client. It is correct that when we came in, there was a detailed security arrangement and a delay, and we're not able to speak to the clients. It's also correct, Mr. Chairman, that accessing the accused persons at Luzira prison is not easy.
In light of the guidance given by the judge advocate and the pronouncements made earlier on by the panel, we are at a loss as to the fate of the ruling which has been pending before this honorable court, because the matter was adjourned. The question that has been put to Council Mpanga is whether he's ready to proceed with the matter. And severally, this matter had been adjourned for purposes of delivering a ruling, and it's me who made the submissions. And from the list they have read, it appears I had no audience. So, Mr. Chairman, would that ruling be still valid? Does it still stand that which is going to be based on submissions made by an advocate who presumably had no audience before this honorable court? So that is a serious procedural matter, so that if it is put out of the way, the anxiety and anticipation will have been addressed, Mr. Chair. We so pray.
The ruling can be delivered? Yes, because he says he wants to know, and I am being misquoted that I am becoming strict with the rules. If you have been practicing in civil courts, they know you. But if you are coming here and you have never been here, we don't know that even last year you are practicing. And what I am advising court is that you must bring last year's certificate to know that you are in a grace period. Others have filed it. So, sir, there is no strict terms I'm bringing. That is my advice, and the ruling, it has always been ready. It can also be delivered so that Council Kwabo gets to know about the ruling, and we proceed from there.
Polite request, which is still on the floor, is that we have a chance to speak to the clients. Yes. Otherwise, Mr. Chairman, it's because...
I don't know. Because what if it was read last time? What would have happened?
Mr. Chairman, the factual position as of now is that the ruling has not been delivered. So we kindly request, Mr. Chairman, that you permit us to speak with the accused persons. hopefully, and perhaps before the ruling. We never know. Practice from the courts of law under the Constitution, this one, which the judge advocate advised us, is that a client can instruct you, and they are at liberty to instruct you before the court makes a final pronouncement on any matter. So to the extent that there was a request or an application by Arias, my senior colleague, it is correct, I wasn't there. He was there and made the submissions. The accused persons were there. And Mr. Chairman, I have not heard an objection from the accused persons and or Mr. Lukwago that they insist that the ruling is heard before we speak to them. To that extent, a polite prayer, Mr. Chairman, and I don't believe it would have anything judicial to this court that would speak to the accused persons before. Might change what we are going through, Mr. Chairman. It is a polite.
Of Aaron Chisa is a very fundamental issue, and until we talk to them, we do not know that what their feeling about it is. So all these are matters that necessitate further instructions from them. I did indicate that each of the advocates appearing is covering a separate aspect. I do not know whether they are going to delegate the area Aaron Chisa was covering. I do not know their decision. So we are respectively again renewing our application that we be given time with the two gentlemen on the dock and before the court resumes.
On the 6th, you had adjourned this court to make a ruling. And my chairman, that ruling has been pending. I therefore kindly pray that guided. My chairman will receive the ruling, and that ruling will perhaps help us to sort some of the issues that were raised by the lawyers for the accused persons. Therefore, my chairman, I pray that read
of instructions are fundamental. They are constitutional in nature. And indeed, you alluded to the fact that none of us here at the bar is at trial, and we are not the ones in the dock. The rights of the accused persons in the dock here are paramount. It's vital and important that before we commit ourselves to receiving the ruling, we have a word with them. Already, I'm being indicted of having made submissions on their behalf without instructions. And the court is going to proceed, or is invited to proceed and pronounce itself on a matter where there are serious allegations that the submissions were made by a stranger to the court, not an officer of court. Those are serious matters that must be addressed. Mr. Chairman, actually it touches on the conduct of the advocate, if that happens. So we do humbly request, Mr. Chairman, that before you proceed to make any pronouncement, we retreat, even if it's not an hour, even if it is 20 minutes, at least we have a word with, and more especially in light of today's happenings, the unfortunate incident that happened before you here, when one of us is not here, Council Aaron Chisa, the assault that has happened in this very room.
No, that one, Council, you have heard. And the bad thing you are talking of what happened, you are not talking about the conduct of your colleague. I thought you are going to withdraw your submissions you submitted the other day if you are saying you are a stranger.
No, I said that is his opinion, that I had no audience at that time. Therefore, if I have no audience...
If you are withdrawing your submissions, then we can...
No, I'm not.
We can leave that at that.
I am not withdrawing the submissions.
Then if you are not withdrawing, let us read
I was making reference to his advice that I had no audience.
Sit down. go out. You go out if you want to go out. If you want to go out, please go out. We can listen even when you are seated. And we have been listening. Now who is who?
The submissions of in the matter coming, which is now before you, were made before we were on record. So we were not in court at that time. That is why our letter has been cited by the member from the registry is dated the 9th of December after the 6th when that hearing took place. As submitted by my senior colleague, an hour might be long because we have lost 2 hours already. We kindly request for a standover. 15 minutes will suffice, just so that we speak to the accused person. So we kindly seek your...
I think you have heard yourselves. Now on the second issue, the court is going to deliberate about the conduct of Council Aaron Chiza. Although you are putting it maybe on the security people, you have seen what he has done. Making a noise, the court have tried to stop him. He could not listen. Banging the angle bars. And it is not his first time to be warned about his conduct in this court. So the court is going to deliberate about his conduct. So that's what is going to be done. And since you have said you are not, we are not proceeding, we adjourn. You have to, what?